Okay. If I could have your attention, thank you. We need to begin the hearing today. Mr. Stylus, are you ready for us to begin?
Yes, Commissioner Deerfield, I am ready.
Thank you. As the Chief Hearing Officer of this panel of the Board of the Human Affairs Commission, I am required to read an opening statement. I urge everyone to pay close attention because this statement lets you know the procedures of this hearing. This is a hearing regarding a complaint of employment discrimination. A charge was initially brought to the Human Affairs Commission by the aggrieved party, Tabitha Roberts. That charge was investigated, and based on the agency's investigation, a recommendation was made that a panel of commission members should be designated to hear the complaint. An order was issued on December 2, 2019, for a hearing to be held today. The Commission notified the aggrieved party and the respondent, South Carolina Food Administration, by way of a notice. Attached to the notice was a copy of the complaint. The notice required the respondent to answer the complaint today. The aggrieved party and the respondent both have a right to legal representation. The respondent, represented by its commissioner, Allison Friedman, has presented them with an attorney, Andrew Singleton. The aggrieved party does not have representation. However, her interests will be represented by agency attorney Rhonda Johnson. Our panel consists of 3 members of the Board of Commissioners, designated by our chairperson, I, Davis Deerfield, and the Chief Hearing Officer, and Commissioners Rodriguez and Jones are the remaining panel members for today's hearings. A record is being made of this hearing by the court reporter, Mr. Miley Stylus. The requirements that written public notices of the time, date, place, and agenda for this meeting have been met. We are bound by the rules of evidence. The board's attorney, Jack Marshall, should assist in assessing the testimony and shall rule on all motions and objections. This hearing will be conducted in compliance with the Administrative Procedures Act and South Carolina Human Affairs Law. I am the presiding officer of the panel, and it is my duty to take whatever action is necessary to ensure an equitable, orderly, and expeditious hearing. The agency attorney and respondent's attorney may make an opening statement before the presentation of their case in chief. Then the agency attorney may call and examine witnesses to support the aggrieved party's complaint. After the agency attorney is finished, the respondent may present its case through its attorney. Each side will be given the opportunity at the appropriate time to ask questions of a witness. As Chief Hearing Officer, I will have the opportunity to ask clarifying questions of the witnesses at any time during the proceedings. Before closing the hearing, the presiding officer will allow both parties to present a brief summation of closing statement if they would like to do so. The agency attorney will have the option of closing first or last. I want to point out that only testimony or evidence persistent to the grounds on which the complaint was made will be allowed. Testimony or evidence which is repetitive, cumulative, or irrelevant will not be permitted. At the conclusion of the hearing, the panel shall have the opportunity to move into executive session and will then come onto the record to state its findings of fact and conclusion as to whether or not the respondent has engaged in an unlawful discriminatory practice pursuant to the Fair Housing Law. An order will be served upon both parties either dismissing the matter or ordering appropriate relief for the aggrieved party, which may include actual damages, equitable relief, and injunctive relief. And with that, we are prepared to begin. Does either attorney have questions or concerns prior to the beginning of the hearing?
No question.
Are all witnesses testify in the hearing present?
Yes.
Witnesses are asked not to discuss this case either before or after testifying until they are excused. This is not intended to preclude the parties after entering into discussion with their witnesses. Does any witness not understand this? No. Witnesses are to remain available after testifying until they are excused by the presiding officer. At this time, the court reporter will administer the oath to the witnesses.
Will everyone who will testify today please stand? Ms. Roberts, Ms. Freeman, and Mr. Patrick, will all the witnesses please raise your right hands? Do you swear to or affirm that the testimony you will give today will be the truth, the whole truth, and nothing but the truth?
Yes. Yes.
Thank you. You may be seated.
Now we'll have your opening statements from the parties. Ms. Johnson, are you ready with your opening on behalf of the aggrieved party?
Yes, Commissioner Deerfield. Thank you, panel members, for participating in this hearing today. This matter has come to you following an extensive investigation by our EEO enforcement staff, led by investigator Kerry Patrick. After hearing from him and the aggrieved party, Ms. Roberts, I think you will agree with me that the respondent is liable for unlawfully denying Ms. Roberts the right to a reasonable accommodation because of her pregnancy and disability, and subsequently terminating her for having requested said accommodations. Ms. Tabitha Roberts is 26 years old and had worked for respondent for almost 2 years as a produce inspector when she informed them that she was pregnant. In March 2019, Ms. Roberts requested the use of an assigned parking space close to the office building when she was about 4 months along. The accommodation was promptly granted. However, in July 2019, Ms. Roberts was diagnosed with gestational diabetes, and she required additional accommodations to remain able to work. Specifically, she needed additional bathroom breaks, water at her station at all times, and breaks every 4 hours to check her blood sugar. As you will hear, Ms. Roberts provided medical documentation to respondent, which included her diagnosis and her need for these specific accommodations. Ms. Friedman, acting on behalf of respondent, called Ms. Roberts into her office later on that afternoon and informed Ms. Roberts that she would be terminated immediately. There was no conversation over alternate accommodations, vacancies available for Ms. Roberts' temporary placement, or leave as a form of accommodation. Ms. Roberts was simply terminated on the spot. Ms. Roberts has been unable to find work since she was terminated on July 8, 2019. Respondent's treatment of Ms. Roberts caused her additional stress, and she required the services of a psychologist leading up to the birth of her daughter. As Ms. Roberts was riddled with anxiety over how she was going to support her child or pay her medical bills associated with childbirth since she had no income. The investigator, Mr. Patrick, and Ms. Roberts will both testify regarding these facts. And at the conclusion of today's hearing, I believe the panel will have no choice but to hold South Carolina Food Administration liable for this unlawful denial of a reasonable accommodation to Ms. Roberts and the subsequent retaliatory discharge in violation of the Human Affairs Law of South Carolina. Thank you.
Thank you, Ms. Johnson. Mr. Singleton, would you like to present your opening remarks?
Yes, thank you, Commissioner Deerfield, and thank you, panel, for holding this hearing so that the South Carolina Food Administration side of the story can be heard. The Commission is represented today by its Commissioner, Allison Friedman, a renowned former professor at Clemson University in the area of food science, who stepped into public service to lead the South Carolina Food Administration to ensure that each and every one of our citizens has access to safe and quality foods. Ms. Friedman denies Ms. Johnson's position that she failed to accommodate Ms. Roberts or that she retaliated against Ms. Roberts in any way. First, Ms. Friedman is herself a mother and knows the discomfort associated with pregnancy. Secondly, Ms. Friedman accommodated Ms. Roberts where she could, but there was no way to accommodate Ms. Roberts having unsealed water at her otherwise sterile station to inspect the produce, particularly in light of the stringent regulations that govern the administration's operation. And there simply is no time to constantly provide bathroom breaks in addition to the regular breaks and even more breaks of blood sugar checks. The conveyor belt does not stop running. Third, Ms. Friedman had no idea that Ms. Roberts suffered from a disability based on poor documentation provided by Ms. Roberts. Finally, Ms. Friedman denies that she terminated Ms. Roberts because Ms. Roberts had requested accommodation, but rather she could not do her job with so many accommodations and termination ensured Ms. Roberts could seek government benefits. It was nothing discriminatory. It was simply altruism. At the conclusion of this hearing, I think you will see that Ms. Friedman meant no harm to Ms. Roberts and was simply doing what she thought was best for the SCFA. And Ms. Roberts and the citizens of South Carolina whose safety depends on the prompt and thorough work of the SCFA, it will be clear that there's no violation of the law, and you will deliver an order in our favor. Thank you.
Thank you, Mr. Singleton. The panel appreciates the opening remarks from both parties. We are now ready to hear from your witnesses, Ms. Johnson.
Of course, Commissioner. My first witness is Ms. Tabitha Roberts.
Ms. Roberts, please step up to the witness stand and take a seat. I will remind you that you are under oath. Also, please speak loudly so that the court reporter can hear what you say. Please also remember to use words in answering questions rather than and hum. These cannot be transcribed properly, so please answer with yes, no, or some other word.
Okay.
All right, we are ready to begin.
Thank you, Ms. Roberts. Please state your name and where you live for the record.
My name is Tabitha Roberts. I live in Marlboro County.
And do you work there?
Well, I used to work at an inspection and shipment facility for the South Carolina Food Administration, but I was terminated when I disclosed that I had developed gestational diabetes as a result of my pregnancy and required accommodation.
How long did you work there?
From October 4th, 2017 to July 8th, 2019.
And have you worked anywhere since then?
No, I had my daughter on August 31st, 2019. But since then, I've been unable to find anything. My unemployment benefits ran out November 25th, so now I have no other income except WIC and SNAP, and it's been really scary.
Now let's go back to when you were employed with Respondent. What did you do there?
I was an inspector. I sat on the conveyor line and checked produce to make sure there were no bug bites or debris, make sure it had gone through the cleaning line and had been properly labeled. And then from my station, it went to packaging and then out to stores.
Thank you. When did you first notify Respondent that you were pregnant?
I notified them in March. I was having a little bit of foot and leg swelling between my second floor apartment and walking so far from the parking garage to and from work each day. So my doctor recommended that I reduce the amount of time that I was on my feet and suggested that I try to get a parking space close to the building so that I could at least reduce the walking during work hours.
And what happened when you requested the parking place and disclosed you were pregnant?
The lady in Human Resources phoned Commissioner Friedman about the request, and within 2 days I had been assigned a spot.
And did anything else occur between getting your parking spot and your request that led to your termination?
No, everything was fine.
Tell me about your next request.
Well, when you're pregnant, you are required to take this glucose test. It's mandatory and it tastes horrible, but it's a solution that you drink. And then they measure your blood sugar after an hour. If you fail that, then you have to go back a few days later and do the same thing in a 3-hour test. And then if you fail that second test, you're diagnosed with gestational diabetes, which is what happened with me. So that meant that I was going to need additional bathroom breaks, water all the time, and to check my blood sugar every 4 hours. So when I went back to work the next day after being diagnosed, I told Human Resources that I had been diagnosed with gestational diabetes and gave them a note from my doctor.
Then what happened?
Just like last time, the Human Resources lady called Ms. Friedman and let her know the request, and then HR told me they'd be in touch and that I should return to my station, so I did.
Thank you. Okay, let the record reflect that I am approaching Ms. Singleton with the medical note. I am now handing Ms. Roberts the same, which has been pre-marked as Exhibit 1. Ms. Roberts, do you recognize this document?
Yes, I do. It's the letter that I gave to Human Resources about my need for accommodation.
We offer this document as evidence now.
Any objection from the respondents?
No objection.
Document will be entered as evidence.
Thank you. Ms. Roberts, what is the date on the letter?
July 7th, 2019.
Then what happened after you gave this letter, Exhibit 1, to Human Resource?
That same afternoon, probably about 4:30, I was called to Commissioner Friedman's office.
And then what happened?
Commissioner Friedman told me that they weren't going to be able to accommodate my requests. She said she'd been pregnant, so she knows it's uncomfortable, but that we can't just go around completely changing work requirements just because someone got pregnant. She said that there was a regulation that stated no food or drink could be at the workstations or on the cleaning and inspection lines of the facility, so I was being terminated.
Did Commissioner Friedman offer you any other sort of accommodation?
No,
Were you offered unpaid leave until you could return?
no,
At any time, did Ms. Friedman offer to look for vacancies to place you in until your restrictions were lifted?
no.
Did Commissioner Friedman say anything else to you during that meeting?
She just said that I was a hard worker and that she was going to do me a favor by terminating me so that I could draw unemployment, and that I should definitely reapply to work there after the baby was born.
Since that time, have you reapplied to work there?
No. After the abrupt termination, which I felt was retaliatory for me requesting an accommodation, I began experiencing extreme anxiety. I had to start seeing a psychologist because I was so stressed out about how I would be able to care for my child and pay for the ridiculous medical bills with no income and no insurance. My psychologist and I discussed me reapplying there, but we both felt that it was in my best interest to find somewhere else where I felt secure and could really build a career and support my kid.
So what did you do?
I filed a charge here with the Human Affairs Commission, and I gave up my apartment and had to move back home with my parents to save costs.
I want to talk briefly about how you've been impacted financially by this situation. Did you have to pay for those counseling visits?
Of course, they were $57 for the uninsured rate, and I went once per week for about 12 weeks.
What about your medical bills?
After I lost my job in insurance, I was billed as an uninsured individual, and the total cost of delivery and follow-up care was $12,000.
Let the record show I am approaching Ms. Singleton with an invoice from Carolina Counseling and Marlboro Medical Associates. Let the record show I am now handing Ms. Roberts the same, which has been pre-marked as Exhibits 2 and 3. Ms. Roberts, what are these documents?
These are the medical invoices I received for counseling and my delivery and follow-up care.
And on Exhibit 2, the Carolina Counseling invoice, what is the total amount owed?
$684.
And Exhibit 3, the Marlboro Medical Associates invoice.
$12,742.18.
We offer this as evidence now.
Any objections from respondent?
Yes, we object to the relevance of these documents. The Human Affairs law clearly states if wrongdoing is found, damages and are limited back pay, and to the extent that they wish to increase any award in their favor by adding these extraneous records is outside the foreseeable damages of the statute.
Ms. Johnson, your response?
Yep.
Okay. Yes, thank you. The statute gives the panel the ability to award equitable relief. These damages are naturally flowing from the termination. Ms. Roberts had insurance at the time of her termination and then had to pay out of pocket for the birth of her daughter, all because of respondent's actions. Respondent caused her to need therapy as well. These are equitable.
Given the broad nature of the evidence allowed under the Administrative Procedures Act, the limited scope of damages that have been explored in similar cases under the Human Affairs law to date, and the fact that Ms. Roberts has already testified to the amounts of the invoices, there seems to be a very small chance of these documents prejudicing the panel members, and to the extent this panel interprets equitable relief, should that be necessary, they may well be relevant. Therefore, the invoices may come in, and this panel will reserve ruling on the relevance of the documents until the conclusion of the hearing.
Thank you, sir. I have no further questions at this time.
Mr. Singleton, do you have any questions for the witness?
Yes, I do. Thank you. Now, Ms. Roberts, I want to talk to you about the accommodation letter from your doctor that you and Ms. Johnson discussed earlier. You have read this letter before, haven't you?
Yes.
And where on that letter does it say that you need an accommodation because you have gestational diabetes?
Well, it doesn't, but I told HR when I turned it in.
You heard the phone call between the HR representative and Commissioner Freeman, did you not?
I did.
Did HR mention to Commissioner Freeman that you had gestational diabetes?
I think so. I assume so. I don't recall specifically, but I think I would remember if that detail had been left out.
But you can't say for sure that Commissioner Freeman ever had knowledge of you requesting accommodation based on you having gestational diabetes.
No, I cannot.
And you never told her explicitly when you spoke to her either?
No, I don't remember doing that. She's the commissioner, so I tended to just listen and let her lead the conversation.
So, what you've said is that Commissioner Freeman had every right to think this was a normal pregnancy based on your note, the phone call from HR, and your conversation with her.
Objection. Calls for speculation. Ms. Roberts has no way of knowing the mental impressions of Commissioner Freeman.
Any response, Ms. Singleton?
I'll rephrase.
Very well.
Ms. Roberts, do you know of any way that Commissioner Freeman could have become informed that you had gestational diabetes based on your letter, the phone call you had overheard from HR, or your meeting with her?
No, I do not.
Thank you, Your Honor. I have no further questions.
Ms. Johnson, any redirect?
Just briefly, Your Honor. Let the record show that I am approaching Ms. Singleton with a documentation from SKIS. Let the record show I am now handing Ms. Roberts the same, which has been pre-marked as Exhibit 4. Ms. Roberts, what are these documents?
This is a printout of my request for absences that I took for doctor's appointments.
We offer this document as evidence now.
Any objection from respondents?
No objection.
The document will be entered as evidence.
Thank you. And looking at the first one, what is that date?
July 1st.
What is listed under the reason?
Glucose test,
And what is the timeout requested?
2 hours.
And the second date?
July 3rd,
The reason?
3-hour glucose test,
And the timeout requested?
4 hours.
And the status of each of them?
Approved by HR.
Now, Ms. Singleton, question you about the contents of your letter for accommodation, which we had discussed as Exhibit 1. Do you recall that?
Yes.
Did HR or Commissioner Friedman ever ask you for additional medical documentation when considering your request?
No.
Thank you. I have no further questions.
Thank you, Ms. Roberts. Ms. Roberts, do you have any additional witnesses?
Yes, at this time, I would like to have Investigator Carrie Patrick take the stand.
Thank you, Ms. Johnson. Mr. Patrick, I will remind you that you are under oath. As discussed before, please also remember to use words in answering questions rather than and Ms. Johnson, you may begin.
Mr. Patrick, please introduce yourself.
I'm Investigator Patrick of the EEO Division here at the Human Affairs Commission.
And how long have you been an investigator?
I began with the agency in 2016, so 3 years.
And what was your involvement with Tabitha Roberts' matter?
I was the investigator assigned to investigate her charge complaining of pregnancy and disability discrimination.
How did you go about doing that?
As with every matter, I reviewed the position by the parties. In this case, Ms. Roberts' charge and SCFA's position statement. I then interviewed the parties and witnesses in the matter. In this case, I did interview the HR representative. I also reviewed any documents provided by the parties. And finally, I thoroughly do a thorough analysis of all the evidence. I recommend to Commission review whether the matter should move forward for a hearing or be dismissed.
And in this case, what did you recommend?
The reason why we are here today is because I recommended that a hearing be held because I determined the violation occurred of the Pregnancy and Accommodation Act and the South Carolina Human Affairs Law, Americans with Disabilities Act existed.
What was your basis for making this determination?
Ms. Roberts provided me a letter from her doctor that included an accommodation request. And in her interview, she told me about the verbal conversation she had with HR and her request to leave based on those related appointments. I sent in a supplemental request for information to SCFA, asking for the SKIS printout, and also interviewed the HR representative, who confirmed Ms. Roberts' version of events and could not recall whether she mentioned gestational diabetes.
Investigator Patrick, please look at Exhibits 1 and 4.
Yes.
Is Exhibit 1 the accommodation letter you reviewed during the course of your investigation?
Yes, this is an accommodation request letter I received from Ms. Roberts.
And Exhibit 4?
Yes, that's the SKIS printout I got when I did the request for supplemental information.
Thank you. I have no further questions at this time.
All right, thank you, Ms. Johnson. Ms. Singleton, anything from you?
Yes. Good afternoon, Mr. Patrick. You determined that Commissioner Friedman not only discriminated against Ms. Roberts on the basis of her pregnancy, but also because of her disability of gestational diabetes. Am I summarizing that correctly?
Yes, that was my recommendation to the Commission.
But Investigator Patrick, you don't know for sure that Commissioner Friedman even knew Ms. Roberts had a disability, do you?
Based on the information I gathered, I believe she knew.
But you can't say that for certain. Under oath, can you?
No, I can't, but again, I'm supposed to make a recommendation based on what I believe the evidence says, and that is what I did.
And unfortunately, we have that evidence here today for the panel to see. So let's talk about the evidence that respondent SCFA provided you. Isn't it true that the denial of the accommodation request for water at Ms. Roberts' station was based on a very long-standing regulation?
It is.
So you would agree with me that it would have been an undue hardship to allow Ms. Roberts to break regulations in order to have her water at her station, putting the lives of South Carolinians at risk?
Well, generally, individuals aren't guaranteed the accommodation request they ask for, but there is an interactive process that should have taken place to determine how to accommodate the request in another reasonable fashion.
Mr. Patrick, I'm not asking you for all of that information. My question is very simple. Isn't it true that if SCFA had granted Ms. Roberts' request for water at her station, that the agency would have been in violation of safety regulations?
Yes, but
Thank you. we'd ask that the panel take judicial notice of ST Code Regulations 8823, which reads, employees shall not use tobacco in any form or eat or drink while engaged in food preparation or service, or while in equipment and utensil washing or food preparation areas, provided that the designated location in such areas may be approved by the Director of Health for smoking, where no contamination hazards will result. Effective date, May 9th, 1987. During your investigation, did you perform an on-site inspection to see the working conditions of Ms. Roberts' job?
I did not, but she explained that she worked on a conveyor line, and her job was to inspect it and make sure there were no problems prior to it being packaged. That was also the description I received in the position statement from SCFA. So there was no reason for me to see the conveyor system.
And what was the break policy?
The line was stopped for a 10-minute break the first 3 hours, and a 20-minute meal period was provided 2 hours later. I had an 8-hour shift. Lastly, another 10-minute break was given at 6.5 hours. Each person was required to be back in their station until the next break. In other words, if you began your shift at 7 a.m., you would get a 10-minute break at 10, a 20-minute meal period at 12, and a 10-minute break at 1:30 p.m. Your shift would end at 3.
In other words, when there are breaks, the whole line stops? Is that correct?
Yes.
And Ms. Roberts was asking for additional frequent bathroom breaks and breaks every 4 hours to test her blood sugar. Is that correct?
Yes, I believe so.
And you agree that she was already receiving a break less than every 4 hours, correct?
Yes, but that would not have accommodated her bathroom request.
So it's your position, Mr. Patrick, that the SCFA should stop the line more than 3 times every shift that Ms. Roberts was scheduled to work.
I did not say that.
But you recommended cause based on her denial of accommodation for her disability, and her request was for more frequent bathroom breaks. Did you not?
I found cause because I felt there was an inadequate interactive process, and that respondent made decisions based on assumptions.
But you agreed that it is up to Ms. Roberts to proceed all necessary documentation to put respondent on notice of her disability, need for accommodation, etc., correct?
Yes.
And she never provided them with a letter linking the accommodation request to gestational diabetes, did she?
No, but again, she wasn't given the opportunity, and she was informed HR verbally. Even if they had tried to work with her and truly couldn't accommodate her, they could have found an option short of terminating her. That was retaliatory and unlawful also.
Let's talk about that determination. Assuming there was no way to accommodate Ms. Roberts and she had been placed on unpaid leave, she would have been out of work, correct?
Yes.
Without income.
Yes, that's true.
But rather, by being terminated, she was eligible for unemployment.
Yes, she received $325 per week, which was much less than her salary.
But much more than $0 has she been placed on unpaid leave, correct?
Yes.
And isn't it true from both your interviews with Ms. Roberts and HR that Commissioner Freeman told Ms. Roberts that she should certainly reapply when she was released from maternity leave?
Yes, that's correct.
And to your knowledge, Ms. Roberts has never reapplied, has she?
Not that I know of at the time that my investigation.
So instead of Ms. Roberts having zero money until her baby was born on unpaid leave and then returning to her job, Commissioner Freeman ensured she would get unemployment totaling $6,500 and could reapply and return to work, making her full salary again. Isn't that right?
I guess so, but there's no guarantee that she would have gotten her job back.
Do you have any reason to doubt the integrity of Commissioner Freeman?
No, I do not.
Thank you. I have no further questions at this time.
Thank you, Ms. Singleton. The panel has no further questions for this witness, and Mr. Patrick may be excused. Ms. Johnson, do you have any further witnesses?
No, Your Honor.
All right, Ms. Singleton, do you have any witnesses to present?
Yes, Commissioner Freeman will testify.
Commissioner Freeman, please take the stand. Okay, Commissioner Freeman, you have been previously sworn in. Again, as I have asked for previous witnesses, please answer questions in complete words. Ms. Singleton, you may begin.
Thank you, Commissioner Freeman. Please tell us where you work and what you do there.
Hello, I'm Allison Friedman, and I'm the Commissioner for the South Carolina Food Administration.
Tell everyone how you know Ms. Roberts.
She was one of our best inspectors. Then she got pregnant. At first, she just needed a parking place, And that wasn't any real trouble. Several months later, she came back and needed more frequent bathroom breaks, water at her station, and breaks to check her blood sugar. It was too much for the commission, as the water was against regulation, and her need for breaks would have required us to constantly and without routine stop the line at her leisure. It was simply more than we could do.
Why was that an issue?
It's a conveyor line. Everyone's job from start to finish in production is on that line. It's like a domino effect. If we stop the wash line, nothing happens for the workers further down the line. Likewise, if we stop the inspection line, the water line backs up and nothing is happening in the packaging line. If we don't have optimal line movement, you aren't going to have fresh produce available in the grocery stores, and that creates food deserts in a hurry, which leave lasting socio-economic damage on a community.
Still, what did you know about Ms. Roberts' health?
I knew she was pregnant.
Anything else?
True. I didn't know anything about her exact condition until this charge was filed. After I got something from the Human Affairs Commission saying Ms. Roberts was asking for an accommodation for her disability, I tried to figure out what on earth that was in reference to. I went back and looked at her letter, and there was nothing on it about a disability. I did talk to the HR representative, and she said she thought Ms. Roberts had gestational diabetes, but that she was never giving any documentation to support that.
Had you known Ms. Roberts had gestational diabetes, what would you have done to accommodate her?
Well, when I read that, I went over in my mind some other options. I was going to call her and tell her we'd hire her back. As you know, she filed this charge almost immediately after her termination, and we got notice 8 days after she filed, so she still had plenty of time to work. But as I thought about other options, I was not finding any way that she could do her job on the line with accommodations. We are a state agency. We can't just hire someone to stand behind her and tag her out every time she needed a break. And I did check with HR to see if we had a vacancy, but there were no jobs that she was qualified for outside of the various lines. So I just decided it was best that she continue receiving unemployment, which we did not object to, and frankly, expedited so that she could get her benefits faster. I already told her she could apply for rehire when she could return. I keep my word.
Thank you. I have no further questions at this time.
Ms. Johnson, your turn.
Thank you, Commissioner Friedman. You said that you didn't know about the gestational diabetes, correct?
I never did while she was employed with our agency.
But your HR representative knew, correct?
Yes, but that was not communicated to me.
But the agency itself was on notice, wasn't it?
Verbally, perhaps, but there was nothing in writing. We do trainings. Our employees know what accommodation requests are supposed to look like.
And you never requested any additional medical paperwork from Ms. Roberts, did you?
No, but again, I had no reason to think more documentation was needed.
You entrust your HR representative to do certain things, correct? So that you, as the face of the agency, are free to do other engagements.
Yes.
Like payroll and benefits,
Yes.
scheduling and vacation and leave requests,
Yes.
and even accommodation requests.
Yes, but I have final approval on everything.
Right, but it wasn't Ms. Roberts who didn't provide you all of the information you needed to make a determination on her accommodation request, was it?
Our HR representative is wonderful and has been with the agency for more than a decade. Look, we did everything we could to accommodate Ms. Roberts. There were simply too many restrictions and confines for us to work around. I'm a mother. I've been pregnant. It's uncomfortable and sometimes somewhat painful. I had 3 interests to consider: the agency, state government, Ms. Roberts, and the safety of all South Carolinians. The result that I came up with was the best for Ms. Roberts. She could have applied and gotten her job back. In fact, she still can. I created a way for her to have unemployment to offset the bills, and I ensured that our agency continued to run and continue to uphold the highest quality standards to ensure the safety of our citizens statewide.
Let's be clear on one thing. You didn't ensure her job back. You told her she could reapply and compete for another job. Isn't that correct?
Well, that's what I said, but I winked at her. She knew the job was hers.
Regardless of your winking, you did not tell her she would be hired back for sure, did you?
I did not. I can't promise individual jobs, but I would have taken care of her, and she knew it.
Thank you, Your Honor. No further questions.
Ms. Singleton, any reply?
No, Your Honor.
Okay, thank you. You may be excused, Commissioner Friedman. Ms. Singleton, any further witnesses?
No.
Thank you. We will now hear closing arguments. Ms. Johnson, as an agency attorney, you have the option of closing first or last. Which do you choose?
I will close last, please.
Very well, Ms. Johnson. Ms. Singleton, you may proceed with your closing remark.
Thank you. Members of the panel, I would like to thank you for your attention today. Commissioner Freeman and I appreciate the time you have devoted to this hearing. Each of you provides a valuable service to the state by serving the Commission Board. I told you at the beginning of the hearing today that Commissioner Freeman is a mother. She understands what Ms. Roberts was going through, and she did everything in her power to ensure that Ms. Roberts was taken care of. Ms. Roberts admitted that her parking request was promptly resolved. Additionally, Ms. Roberts admitted that she was eligible to receive unemployment benefits because of Commissioner Freeman's handling of the situation. Finally, Ms. Roberts admits she was free to apply to get her job back. And even Investigator Patrick acknowledged he had no reason to doubt Commissioner Freeman's integrity. You heard the Commission provide trainings for its employees on how to request accommodations and what documentation is needed. However, you will see in Exhibit 1 that there is no mention of the term gestational diabetes on the paperwork. Excuse me. Commissioner Freeman met one-on-one with Ms. Roberts, and even as Ms. Freeman was explaining the situation, Ms. Roberts never once offered that the accommodations were for her disability. You will recall that Commissioner Freeman was not informed of the disability until she received notice of the charge that gave rise to this hearing, and that she went through in her mind any other accommodations she could think of to assist Ms. Roberts, but ultimately found that the arrangement she had created was the optimal solution for all parties. And now, you are being asked by Ms. Roberts to make the state pay her lost wages to present when she has made no efforts to reapply for her old position, despite very strong occurrences and testimony from Commissioner Freeman. On top of that, she wants you to award her damages for therapy as some form of equitable relief without any testimony from her doctors or medical or treatment notes. Everything you've heard from the SCFA has been backed up by documentation and regulation. We ask that the panel go back through those exhibits and ask if those accommodations sound reasonable for a healthy pregnancy, or if, given the documentation Ms. Roberts had the burden of providing, it would be possible to know she needed those accommodations because of her diagnosis of gestational diabetes. Your job today is not to imagine in your mind the realm of possibilities of what could have been done to accommodate Ms. Roberts. Instead, the person in the best position to know that those accommodations would have constituted undue hardships to Commissioner Freeman. And she has testified that she did everything in her power to protect the interests of the agency, Ms. Roberts, and the safety of South Carolina. Undue hardship is today and always has been a lawful reason to deny accommodation, regardless of the Pregnancy Accommodations Act, or the Human Affairs Law, or Americans with Disabilities Act. That undue hardship left Ms. Roberts with two options: unpaid leave or termination with benefits. Commissioner Freeman chose the best outcome for Ms. Roberts. Based on the evidence presented today, I trust you will return an order finding that Commissioner Freeman did not violate any state or federal law. Thank you.
Ms. Singleton, we appreciate your remarks.
Thank you, Commissioner. I'd like to begin by saying that I join Ms. Singleton in thanking you today for your time and patience. Ms. Roberts truly appreciates having the opportunity to present her complaints to you, and I believe you will be fair and logical in assessing the evidence presented. Panel members, here is what Ms. Singleton is asking that you forget. While Ms. Freeman may be in the best position to determine an undue hardship, Ms. Roberts is in the best position to know what accommodation will best meet her needs. Pregnancy is never a one-size-fits-all situation, and disabilities are certainly not either. That is why the interactive process exists. The employee, Ms. Roberts, knows what is best for her body and her baby, and the employer, represented by Commissioner Freeman, knows what is best for the agency. Together, they are supposed to work together to determine the optimal solution for all parties. It is not enough that Ms. Freeman ran through her list of potential ideas in her head and called it a day. That interaction is supposed to take place between both parties. Finally, it is not up to the Commissioner Freeman to choose what is best. For Ms. Roberts may decline any accommodation and continue working at her own risk. There is no question. Ms. Roberts did not want her job to be terminated. She testified she suffered extensive anxiety over not knowing how to afford her medical bills, how to handle her loss of insurance, and how to cover the needs of her child thereafter. Make no mistake, Ms. Roberts would not be in the financial or emotional state absent the unlawful actions of Ms. Freeman. The loss of insurance and income and the resulting anxiety all flow directly from the bad acts of SCAF, and it is only equitable that they be responsible for the same. The most knowledgeable person about this investigation looked at the evidence, the same evidence you have before you today, and considered the written statements and interviews with the parties. Investigator Patrick found that cause existed as to denial of accommodation for pregnancy and disability, and cause as to retaliation based on the prompt termination of Ms. Roberts after her request for accommodation. To the extent that Ms. Freeman denies having knowledge of the disability, it does not matter. Ms. Roberts followed policy and informed HR. The HR failed to inform Ms. Freeman is no fault to Ms. Roberts. The accommodations were denied and the result was termination because of the accommodation requested. That is retaliation. And that is why, members of the panel, I ask that you hold Commissioner Freeman accountable for her actions and inactions and fully compensate Ms. Roberts for the unlawful conduct. Thank you.
Thank you, Ms. Johnson. That will conclude the hearing today. I appreciate everyone's involvement, and as I mentioned earlier in my opening statement, our commission panel deliberates in executive session. We will come back on the record after we've reached a conclusion. Before I call for us to go into executive session, is there anything further from the parties?
Nothing further.
All right, do the panel members agree to go into executive session?
Yes.
Yes. Okay, then please excuse us while we adjourn. We will call everyone back before providing our conclusion following discussion in executive session.